The House is concerned about the plethora of petitions and save our soul appeals from Nigerian citizens across the country in recent times about the untold hardship and poverty they are experiencing from extended freezing of their personal, corporate, and other accounts by the Central Bank of Nigeria. Reports of the current unprecedented freezing of over 5,000 bank accounts in Nigeria by the CBN and the allegations of injustice, illegality, victimization, and prejudice by the CBN against innocent Nigerians in the freezing of their accounts. The burgeoning number of accounts being frozen by CBN in Nigeria appears to be taking a huge toll on the nation's economy and livelihood of millions of Nigerians and underscores the seeming flagrant abuse of this power by the CBN when compared to the central banks, treasuries, and Federal Reserves of other climes. The House is worried about innumerable allegations from affected Nigerians that the CBN, in its claim of exercising the CBN governor's powers to freeze bank accounts under Section 60B of the Banks and Other Financial Institutions Act, BOFIA, 2004, incessantly violates Nigerians' fundamental human right to fair hearing and presumption of innocence until proven guilty, as enshrined in Section 36 of the 1999 Constitution of the Federal Republic of
Chairman
Nigeria,
Business,
as
Chief
amended.
Business and Rules.
When it freezes accounts arbitrarily for extended periods without the knowledge of the account holder, the provision of an opportunity for the account holder to provide an explanation or referral of the matter to an appropriate regulatory authority for proper investigation as required in the related section of the Act. Although this section of the Act does not expressly indicate the requirement for an opportunity for fair hearing for the account holder, Section 1, subsection 3 of the 1999 Constitution is explicitly clear about the supremacy of the Constitution over any other subsisting law and presupposes the CBN should be aware of its obligation to observe constitutional provisions in the exercise of any powers under any law. The House is also worried about the preponderance of allegations of contraventions or provisions of the law by the CBN in freezing accounts without obtaining a valid court order, obtaining a court order after the fact when the account holder raises an alarm in this regard, freezing of accounts that are unconnected to the account suspected of involvement in a crime, and the inhuman and insensitive application for ex parte orders to freeze accounts for up to 6 months, 180 days, without considering the hardship this action might bring upon innocent Nigerians involved in legitimate transactions and who depend on the funds in these accounts for their remuneration, business transactions, and daily sustenance. The indefinite freezing of accounts without referral to appropriate regulatory authorities for investigation, without renewal of the initial court order authorizing the freeze, even after the investigations have been concluded, is another issue that has been highlighted as part of the allegations. These actions, if confirmed, give credence to the allegations that the CBN is complicit or allegedly complicit in the pursuance of political and personal vendettas against innocent Nigerians without just cause. The House notes the contradiction of Section 60B of the BOFIA 2004 Act with provisions of subsisting legislation like Section 6, 1D and 2 of the Money Laundering Prohibition Act 2011, which in the first instance expressly provides for fair hearing for the account holder before reporting the matter to the Economic and Financial Crimes Commission for further action if necessary, including putting a restriction on the account in line with the already existing statutory powers of the EFCC. Section 16 of Nigerian Financial Intelligence Unit Act 2018 limits the power of the director to only placing an account under surveillance. Section 43 of the Independent Corrupt Practices Commission Act 2000 empowers the Commission's chairman, after obtaining a court order in this regard, to direct the receipt and inspection of all information related to any bank account under investigation, and Section 34 of the EFCC Act, which is the original legislation that authorizes the freezing of any account in Nigeria before the advent of Section 60B of BOFIA. The House also notes that while the EFCC, ICPC, and NFIU, by virtue of their primary statutory functions, are required to be equipped with the requisite intelligence resources to carry out investigations into suspicions of financial impropriety, only the EFCC is empowered to freeze bank accounts after obtaining the valid court order, which is more in consonance with the modus operandi in other crimes. The primary statutory function of the CBN, as enshrined in the CBN Act, is not the investigation of suspicions of financial impropriety, and hence it is obviously not equipped adequately with intelligence resources to do so, and emphasizes the expedience of the National Assembly to revisit the provisions of Section 60B of BOFIA 2004, and this is why probably this section was conspicuously omitted from the current proposal for the amendment of BOFIA that is before the National Assembly. The circumstances surrounding the original inclusion of Section 60B is another issue that has come up, as this section was omitted from the laws of the Federation of Nigeria 2004 and was brought in afterwards as an appendix. Finally, the House is concerned about the plethora of impending litigations against the CBN, which every Nigerian constitutionally has the right to institute, but that will distract the CBN from its primary statutory functions and unnecessarily expend monumental taxpayers' funds for the acquisition of legal representation by the CBN, which should ordinarily not have been expended, but for the indiscretion, if found to be correct, of its employees. The House finally resolves to ask the CBN to commence a review of all currently frozen accounts in Nigeria and to, after 1 week, remove the freeze orders on accounts frozen under the following clear violations of the provisions of the 1999 Constitution of the Federal Republic of Nigeria as amended and Section 60B of BOFIA 2004. And these violations include accounts that were frozen before a valid court order was obtained, accounts frozen without obtaining a court order from the required court of competent jurisdiction, accounts frozen without providing the opportunity for fair hearing to the account holder, accounts frozen but till date have not been referred to the Nigeria Police Force, National Drug Law Enforcement Agency, or any other appropriate regulatory authority for investigation as is provided for in the Act, accounts that were frozen that are unconnected to the accounts suspected for involvement in the commission of the crime, accounts remaining frozen after court-authorized period of freeze has elapsed without obtaining a fresh order from a court of competent jurisdiction, accounts remaining frozen even after concluded investigation has not indicted the account holder, and accounts frozen without documentary proof of petition or reason for suspicion of involvement in the commission of a crime. The House also resolves to mandate the House Committee on Banking and Currency to immediately invite all relevant and affected stakeholders to a public investigation of circumstances surrounding the freezing of all accounts currently frozen by the CBN in Nigeria, with a view to identifying any cases of contraventions of statutory provisions by the CBN in the freezing of accounts, any verifiable cases of victimization or vendetta against account holders by the CBN in the freezing of their accounts, to identify provisions of the Subsisting Enabling Act that might require immediate amendment, considering the tendency for abuse by the CBN, ambiguity of related causes, contradictions with provisions of other subsisting legislation, jurisprudence, or global best practice, and controversies surrounding the addition of related section of the Act after amended version of the Act have been published in the laws of the Federation of Nigeria, 2004. And also mandate the committee, where appropriate, to recommend sanctions against erring staff of the CBN, especially where these allegations have been confirmed, and considering the importance of the administration of this portion of the Act by the CBN Governor. The committee will be required to submit a formal report to the House in 4 weeks for further legislative action. I so move, Mr. Speaker.